Hello. Hello. My name is Keisha Brown, and I'm the founder and CEO of Justice Connection. And you are joining us for navigating the DEI rollbacks for federal employees and contractors. This is a time that we are in, and it really pressed upon me, especially as I received calls and emails and people reaching out, not knowing what to do, right? And the news sets a new headline every day by the hour on how this administration is attacking DEI. And so we've gathered together to be able to share some incredible legal insight from attorneys who have been working on federal employment, federal business level for quite some time, as well as legal experts and DEI traumatic employee consultants. So we're bringing the holistic package today to you, and I want you to feel comfortable to not only listen and learn, but also to engage and lean in. So please feel free to give your feedback or your thoughts and your questions in the comments, and we'll stay abreast of those so that we can make sure that this is a conversation, even though we're virtual and folks are tuning in from all over, but to really be connected in this, because the better informed we are, the better knowledgeable we are about our resources, the more likely we are to be proactive and not sit back and feel attacked, but actually be prepared. So I want to bring in our moderator, who is an amazing woman, Sasha Thompson of the Equity Equation. I'm so honored that you are in partnership, for this conversation, because you have made it your mission and the work that you bring to the community around not just lifting up diversity, equity, and inclusion across professional sectors, but also really recognizing the trauma, the psychological trauma that is really present, that we don't talk about, we don't acknowledge, and you have been able to really incorporate so many different aspects of this. So it is an honor to have you here with us and to help moderate this conversation so that we can really do a deep dive here.
Keisha, thank you so much for having me. And it's funny because I think we both thought of each other when all of this started happening, right? Yeah. Like I started reaching out to you, you were reaching out to me. And this is a conversation that, we've both been having in circles. I immediately, jumped up and said, the only thing that I know to do is create community and share resources. And so, for those who may not know who I am the founder of the Equity Equation. You can go to our resource page. We have resources that will help anyone that is kind of dealing with this. Some of the attorneys that we'll be talking to today are on there. Justice Connection is on there. We want to make sure that you are not just informed, but you are connected as well, as connected as can be. Because I know that there's a lot of fear. I know that some of the folks that I've talked to that are in the federal government feel like they are, especially in DEI roles, right, are cut off from their agencies and not quite sure what is happening. And so I think the conversation we're going to have today hopefully will bring some light to some people, create some clarification for others, and start a path forward. Because right now, this administration is operating in the fact that there's a lot of confusion, right? And when there is confusion and chaos, they can kind of push forward. And so what we need to do is remain steadfast, know who we are, and continue to operate in this space. So I want to bring in the guest that we have to have as part of this conversation. And Keisha, I believe you're going to do the introductions of these esteemed lawyers as we start this conversation.
Yeah. And I want to invite folks in the comments to let us know where you are, right? Like, where are you? Are you a federal employee? Are you a federal contractor? Are you someone who works in the private sector? Let us know your thoughts too as we're engaging because I think what happens from forums like this, people get to hear other people share in addition to learning sort of what resonates, right? So we all don't live in our silos, even though post-COVID we are in our own cubicles, if you will, at home sometimes, but that building community is so essential right now, right? And recognizing that you don't have to suffer or question or wonder in a silo by yourself, right? And that there are resources. And some of those resources I'm excited to bring to the table because they're legal resources. And oftentimes we think of legal as a nice to have and not a must have. And in today's environment, you must have legal counsel on some level in your kitchen cabinet. I'm not saying everybody needs to go hire a lawyer on retainer tomorrow, but you got to know that when you have these questions around, hey, is this right that's happening at work? I'm getting these documents. My supervisor said this. This is what's happening. The policy change. I thought I was in the union. All of these things are happening in a way, especially by our federal government, which we're not used to, outside of the constraints of not only policy and procedure, but also of the law itself, right? And so your questions are not singular to yourself. Trust me, lawyers are working through these questions in real time themselves as we are confronted with an administration that is using inflammatory language in ways to try and shift the letter of the law so that people feel, uncertain about it at best, and at worst, feel like the law itself is not legal, if you will. So having legal counsel at this juncture is essential. And that's why, we wanted to, Sasha and I was like, let's come together in this, because lawyers know a lot, right? Like, I have the advantage of, as running the first Black attorney referral network, I know a lot of lawyers, right? I went to law school, my colleagues, and then now building this amazing network. So I'm always tapping in, right? To hear what their thoughts are and to learn. And I want you to have that same access as well, quite frankly. So I'm going to invite Carrie Davidson to the stage. Carrie is an amazing practitioner here in the DC, Maryland area, who handles a number of things for not only businesses who work with the federal government, and for those who don't, quite frankly. He's got a wide array of business clients, but also on employment law cases, right? And being able to work with folks who are dealing on a federal level or state level and local level. We'll get into that, around how they protect their employment rights. And then also want to bring Todd Yeary to the stage, attorney who is barred in, let me get this right, Maryland, Illinois, DC, Alabama, and he's pending in another jurisdiction, but I'll hold there. And his work has really focused and leaned in on civil rights protections, and that includes employment law, as well as a variety of other civil rights areas. And so the scope here, and don't let my bios limit them, because both gentlemen have vast experience, right? And recognizing the cross jurisdiction around practice areas of the law that often involve many different areas of whether it's civil rights, employment, injury, criminal aspects. All of that stuff sometimes intersects. And so I'm really honored that both of you have joined with us this afternoon. And if you're on the West Coast this morning. So Sasha, these are our people. Wonderful. Well, we actually might have a special guest a little later, so I'm gonna tease that right now. But yes, I'd like to bring Todd and Carrie.
Yes. So I want to start off by asking, and I'll start with you, Todd. What is going on right now? Right, we've had the executive orders that have come out, and for many people, executive orders equal the law, but that's not accurate. So can you talk to us a little bit about what is actually happening right now?
Well, Sasha, Keisha, Carrie, good to be with you today. You asked the fundamental question, and you've invoked certainly the creative genius of our social our sociologist practitioner Marvin Gaye, what's going on, right? Um, and when we think about it, the real question is, quite honestly, we don't know. There's a temper tantrum happening on aisle 3 of the checkout line at the grocery store, and the rest of us are trying to figure out where are this child's parents and when are they going to come get him. All right, so that's number one.
That
So
part,
that
yes.
means then that we shouldn't spend a lot of energy trying to figure out what's going on in his head. We have to be clear on what is actually happening in what they are positioning as a transaction. And what they're saying is they want to reduce the size of the federal government, but they don't want to do it the way a reduction in force is typically done. And so there are regulations in the code that inform how that's supposed to be done. They just send a blanket email to all of the civil service workers and say, you have until midnight tonight to be able to take this deal. And if you take this deal, we'll pay you not to come to work until September 30, the end of the fiscal year. But in effect, you're going to sign away your rights. You don't really have any recourse. And therefore, we then get to, if they decide not to reduce the size of government, put in your place the people they're really trying to get in place to run the government. So let's be real clear on what this hustle is. At the end of the day, I went to law school late in life. I became a preacher a little younger in life. I was a hustler before that. And so I'm a recovering sinner. And so when I put on my hustler antenna, it says to me that this is really a trick at some level to try to get folks to self-select to remove themselves from government. I don't believe there's going to be a reduction in force to speak of, but in reality, what they're trying to do is figure out, can they create vacancies that will allow this administration later to put in place who they want to be in place to be able to run the government from the inside.
Yeah. As a sociologist, I appreciated the Marvin Gaye connection there. So it's interesting because I spent 10 years in tech. So understanding what happened at Twitter, I'm seeing the same thing happening here with these clauses or these deals that are being put out there. For some, and again, I believe if you're close to retirement, it may make sense. For others, it may not. So, Carrie, I want to find out from you, what should people do right now? Because again, as I said at the top, I'm hearing from a lot of folks that are in agencies, especially if they're in a DEI role or a DEI adjacent role, they're being cut off from their agencies. They don't have access to their .gov email addresses. So what should they do?
Now, are we talking about the folks who are actually employees, or are we talking about federal contractors?
So we're talking about employees first. So thanks for that clarification for the employee side.
So, if you're an employee, and I mean, I guess and obviously what happens now is a different question depending on what your situation is. So what you should do really depends on, it's not the same for everybody. There are, as you mentioned, there's certain categories of people who could benefit from a situation like this where they're paid for 8 months, theoretically, right? Somebody who's 6 months from retirement. That's a deal to think about, right? That may get you over the threshold without having to work. Someone who is just starting a federal job, who's not sure that they like the job, who's confused about which way they want to go. You can step back. You can get 8 months of a break with pay. You can go in a new direction. That could be something to really consider. What I think, no matter who you are, what you should be aware of is a few things. One is you should go, especially if you've been in federal service for a long time, you should coordinate with OPM, and you should know what your numbers are going to be as far as when you retire, what kind of packages are available to you if you retire at different ages, with different amounts of service, what that's going to look like in terms of your monthly payout, how your accrued vacation is going to be treated, how your accrued leave is going to be treated. This you should be doing whether or not these executive orders exist. And if this is the impetus to get you to start doing that, for that, it's a good thing, because I tell everybody, you really need to be aware of what your rights and benefits are in your job right now, and not enough people are. So, if you're part of a union, go ahead and read that union handbook. go through the grievance procedure, figure out what rights you would have with respect to termination, coordinate with OPM, know your numbers as far as, what's going to happen if you retire, when you retire, at least get that information. You cannot make a good decision without that information. So if you haven't gotten that information yet, you're probably not able to make the most informed decision on this February 6th issue that we're all facing.
Yeah. You said something about contacting OPM. Business isn't as usual, right? We now know that there are 19-year-olds, 20, 24-year-olds who, as Todd said, where their mamas and daddies, but that's a whole other conversation, that are now a part of these systems, right? And now part of OPM. And so can people trust the information that they are going to receive?
I would say generally they should trust it, in the sense that, the numbers are what they are. A lot of this data has been pre-calculated, is available for you. A lot of it's just formulaic. The formulas are going to stay the same, based on your years of service. They're algorithms that are set up to comply with the statutory benefits that are laid out in the Code of Federal Regulations. So the short answer is yes, I would trust specific numbers from OPM. And if you are misrepresented by OPM, then the government's got a problem there. And that is going to give you some legal recourse to the extent that those numbers aren't accurate. So the short answer is yes. I think, there's some things obviously you got to be careful about trusting. Numbers from OPM, I would trust them.
Yeah, thank you. So one of the things that has been going back and forth, and Keisha and I were talking about this earlier today, is this demonization of diversity, equity, and inclusion, right? First of all, we only hear DEI, and so people assume that they know what that is, without using the full terminology, right? Diversity, equity, and inclusion. And so there is this conversation that if you are in these roles, you are doing something illegal. And so, Todd, can you share, or actually, I'd like to hear from both of you. I'll start with you, Todd, though. Is DEI work, diversity, equity, and inclusion work, illegal?
No. As a matter of fact, DEI work under the current statutory framework of the federal government is the law, right? The whole point of having equal employment opportunity was actually created in response to the fact that there were certain categories of otherwise viable candidates for employment who had been historically excluded by practice. It was the way things were. And very often DEI gets demonized as being exclusive to the question of race. But remember, race, gender, ableism, religious belief, ethnicity, all of those things kind of fell into the category. And so this has been a 60-year chaotic frenzy since President Kennedy, in an executive order, first used the words, we call it DEI now. DEI has now been conscripted to be affirmative action, which means it's a denial of white people to have exclusive priority to federal jobs. And so let's just be real clear on what's going on here. In the end, if we were to look at the employment numbers writ large across the federal sector, you still do not see the kind of diversity that you would expect in some of these federal agencies. So what this is this a campaign ploy, right? Let's just be real clear. And it gives them the reason to drop this panic of, let me put out this opportunity for folks to voluntarily decide that they're going to leave early, with the enticement that I'll pay you to the end of September, so that then we don't have to follow the rules in the Code of Federal Regulations as it relates to agencies deciding how they're going to reduce their workforce. At the end of the day, what they want is everybody to just walk up to the Monopoly board and start rolling the dice, but nobody's read the rules. And so we've got to be real clear on where this is. And to Carrie's point, you don't have time if you've not made a decision yet. And here we are less than 12 hours before, at least on the East Coast, before you can make a decision to get the feedback. And there are a number of all 2 million plus federal employees are confronted, even those in critically staffed positions. So now you're put in the uncomfortable position into a binding agreement. On 2 days ago, there's a memo that was sent out from OPM that had its FAQs and a draft template of what the agreement would look like. And what's included is the waiver. And so even if you decide that this is what you want to do, and later on you decide to change your mind, you're locked into it. And this is, to Carrie's point, if you're near retirement and this next 6, 7, 8 months gets you where you need to be, that's a different conversation. Right. But if you're mid-career, you're past the career conditional status of having been employed by the federal government less than 3 years, and now you have a career appointment. That's a little bit different, with the employment prospects in the current economic reality being suspect at best in terms of being able to find a comparable job. So you really got to look at it. And the first thing is, and Carrie's right, depending on your situation, you got to look out for number one and number one only, but you got to read the fine print.
Yeah. You know, Carrie, I want to follow up with that, because I was speaking to someone who is in the human resources arena, who is in a federal position. And she made the point that she noticed there was no severability clause in what was sent out. Can you explain what that means and the impact that that could have?
Well, now, are we talking about from the standpoint of the waiver of your rights to sue for discrimination with respect to the severability clause?
Yes.
Okay, so I mean, the idea with most of these waivers, if you're going to basically give up your rights when you resign, you're going to waive all claims that you would have for any discrimination that you suffered against the government. That is an independent claim with independent value. Right. So if you have been discriminated against for the last year in the federal government, and you're considering, it's been continuing discrimination, maybe you've got a complaint already filed with EEO, or you're thinking about filing a complaint, the money that you would be entitled to as far as a settlement of that claim, the value of that claim that a judge would give you, that's an independent value from what you're going to get from this buyout. However, if you accept the buyout, you have to be aware that all of the value that you may have in any claim you may have against the government would merge into that buyout payout. And you may forfeit essentially any claims you have against the government for anything. Could be for back pay that you were owed, whether it's discriminatory or not. So, and I have not, unfortunately, I haven't read the release that employees are supposed to sign. But it's very likely that release, if it's like all the other releases that I read, it's going to require you to forfeit any claims you have against the federal government, out, not just this, the claim to this buyout money, but claims to, merit pay disputes you may have had with previous promotions, discrimination stuff. You may be eligible for some back pay. All of that is going to get wiped out, depending on the language of this release that you sign. So you've got to be extraordinarily careful, not only about, the right, the benefits that you'd receive, but the rights that you would give up if you would accept a deal like this.
Thank you. Because I think that there's a notion out there that, I can sign this and I'll be okay for the next few months, and I can also sue. So you just clarified that you can't do both. Right. Right.
I mean, if the way this is going to be framed, if they have any sense at all, is they're going to have you sign a forfeiture of all of your claims against the federal government, and you will not be able to do both.
Yeah.
And let me just read it, because they sent out a template for what the agreement would be. OPM did. And so at paragraph 10, by signing this agreement, the parties acknowledge that they have entered the agreement knowingly, voluntarily, and free from improper influence, coercion, or duress. Duress is particularly important. You send a mass email out and you say, well, we're going to offer you this buyout, and if you don't take it or else, well, that's duress. So that's interesting. You're now saying you're not under duress. Employee understands that except as provided in the reference to the age discrimination clause, this agreement cannot be rescinded except in the sole discretion of the agency head, which shall not be subject to review by the Merit Systems Protection Board or any other forum, and waives all rights to challenge the resignation before the MSPB or any other forum. That is so broad as to basically say, once you sign up, you're locked in. And so September 30th is your date unless you decide to go sooner.
Yeah.
I think one of the things that comes up, right, when you listen to both Carrie and Todd, Sasha, and reading even the letter of, what the waiver says, is the importance of having legal counsel to be able to not only understand what the document is saying and not saying, but also how it uniquely applies to you and your employment situation, right? So those two pieces coming together is critical, right? Being able to have someone who can give you a personal assessment around how this could potentially impact you can only really be done, if I may, on a one-on-one level, right? So it's important to necessarily, of course, read everything, check everything, use your resources, and also recognize that this is not a one-size-fits-all, right? That how this impacts your professional career, or whether you're a subcontractor or an employee, whether you're a manager or you're a supervisor, or whether you are part-time or full-time, whether you're at retirement, whether you're on probation, so many different factors, right, go into how these, what's being played out before us on a day-to-day, week-to-week basis is very different, right? And so I think it's important for folks who are in community working together, sort of joining forces, if you will, as they're experiencing this, but to still also be very cognizant that how this plays out for you is how it's going to play out for you, which may be different than your colleague who sits right next to you as well.
Thank you for that, Keisha, because that now I want to go back to Carrie and specifically talk about contractors, because you had asked, was I talking about employees or contractors? So tell me, what is different about contractors in this space?
Well, contractors aren't federal employees. They don't have any of the protections that federal employees have. They're depending on the federal government to pay them for services, but they're out they're sort of out there in the jungle in terms of protections. If they don't get paid, they don't have a lot of recourse through a lot of agencies, besides those agencies that deal with contract appeals in the court system that deals with government contracts, up to the U.S. Court of Federal Claims. So you're not gonna get these employment protections and these merit protections that you're gonna get in the federal government. That's the short difference.
Yeah, thank you. I want to bring in our special guest, if she's still there. So Monique Dixon is the executive director of the Gibson Bank Center for Race and the Law, and has worked in the federal government. And so Monique, I want to first thank you for joining us. And I know you have to kind of come in and out, but I wanted to get your voice in here because I think from a policy standpoint, I want to make sure that people are clear on what is real, right, versus what is the noise. So can you provide us a little bit of clarity there?
Sure. Well, good afternoon, everyone. And thank you, Attorney Brown and Attorney Yuri and Davison, for your guidance on this issue, on these issues that we're confronting. As was shared, a year ago, last year at this time, I was a federal employee. I served as the deputy secretary for policy at the Office for Civil Rights at the Department of Education. And I was a political appointee. So I was in yet a totally different category of federal employee. So I served at the pleasure of the Biden administration. And one thing that was mentioned is, executive orders are not law, but they are directives to the federal agency that serves under a president. And so, political career staff are to comply with those orders, but federal executive orders do not override federal laws. And so I think the one message that I want to leave with you is, if you decide to stay, if you decide not to opt out and to remain a federal employee, and if you're working in offices that advance diversity, equity, inclusion, and accessibility, just know that the civil rights laws have not changed, and that diversity, equity, and inclusion and accessibility programs in and of themselves do not violate the law. They are generally and categorically, alone do not violate the law. You would have to look at how the programs are put in place and consider different aspects on the program and assess based on the totality of the circumstances in each case whether there is a violation of one of our several civil rights laws. So know that if you decide to stay, that what you're doing it complies with the law, unless there are circumstances in which you are treating people differently based on race or disability or age or any one of the other protected classes. And even that, you would have to go through an extensive review of how programs are carried out, or if you are creating a hostile environment because of your program. And again, there are lawyers and courts love tests. So there are many tests that you would have to, courts will consider to determine whether that happens. So I guess, I just want you to know that there are folks out here who have served. We know you. We've seen the work of career federal employees. I could not have done what I did as a political appointee in the Office for Civil Rights without many of the federal career employees and contractors. So thank you for your service. We see you and appreciate your work. If you decide to stay, know that there are people outside in state government who were formerly federal employees who continue to value diversity, because we know that we need diversity in order to prepare our students for careers and for our workforce to be prepared to interact internationally. So thank you for your service again. And thank you, Attorney Brown, for allowing me to just step in briefly and to listen and to hopefully encourage some of my former fellow federal employees and contractors.
Thank you so much. I do have one question for you before you go. And I saw it in the chat and I was not ignoring it. I just wanted to figure out the best way to pull it in. You spoke specifically about accessibility, right? And so when I think about accessibility, there's ADA, there's so many laws that are in place around accessibility, and this is being pulled back. What does that look like, right? I'm always the one that's thinking of, okay, who can't access a building, right? That's part of DEIA in many cases, in many instances. I think of Governor Abbott, right, who is now put out his own EO around, or his own order around DEI work from a wheelchair. So talk to me a bit about, what could this look like if this is rolled back and states then pick this up? How could this specifically impact accessibility?
So accessibility includes what you mentioned, physical disabilities, but it also includes disabilities that aren't as visual, right? So you may have, for example, a health concern, diabetes or hypertension that may impact your ability to work. And there are accommodations that are made for workers who have those disabilities. And if the accessibility is rolled back, that could lead to, allegations of discrimination. So again, diversity, inclusion, equity, and accessibility is are practices intended to prevent discrimination, right? So you want to build awareness among the federal employees about what the laws are to make sure that everyone is included and accommodated. If an individual believes that he or she or they are not being included because of their race or disability, then there are federal civil rights laws that will protect them and will continue to protect them.
Thank you. And there was one other comment, and I can open this up to anyone that would like to answer it, around just the changing of nomenclature, right? Changing program names from DEI. I've seen a lot around just focusing on inclusion. SHRM has come out and saying, you know, they're now focused on merit, which is a whole other show we can do, but they're focused on merit. You're seeing things around belonging. I recently saw a list, I want to say it was close to 200 words that they are looking for in contracts that are flagged. So if you see any of these words in a contract, then there's going to be like, we're not going to do it. So I'm not sure who would be the best person to respond to that. But is there some legality, some legal recourse that can be used? Because again, most of these are words like inclusive workforce, right? Equitable outcomes, underrepresented communities, which are protected by the law. So is this overreach, or is this kind of the new normal? So I'm not sure who would want to jump in on that one.
I can take a stab at it. I mean, I think, you know,
everybody was brewing on that one, just so you know. Everybody was like, wait a second.
Right? Because we don't know. There's so little we know, right? So it's very tough to opine. But if I was representing, you know, say a government contractor, and, you know, they're trying to figure out, okay, well, what do we do? Because we've got these policies. We want to hire a diverse staff. We've done that before. How do we continue to do that? And so the first thing to do is, like, if you have an external facing policy, a website, something that explains how you do what you do, you know, take out the words diversity, equity, and inclusion. Just don't have any of those three words anywhere in your policy. All right. That's the first thing. Because those words, like you said, those words are going to matter. People are going to look for those words. If you take them out, that's one red flag that won't raise. You don't change anything you do. You just take those words out. And then the second thing is just, you know, internally, you don't want to express that you're hiring someone because of the D, the E, or the I, but you also want to make sure that you're not hiring someone. You're not discussing hiring someone solely because of their status as being in a protected class, right? We're looking for more Black people. You know, we want to hire some more women. You don't want to have those discussions internally, especially like in an email that could be, you know, produced or, you know, some witness saying, you know, we used to have these meetings and this is what we talked about. You don't want to openly discuss protected classes. What you can do, and because that's what lawyers do, they give you options about what you can do, is, you know, say you want to hire 20 people from an HBCU. What you say is, well, look, you know, Jackson State's a great school. They've got phenomenal candidates that we think have merit. We'd like to go recruit over there, right? And that's it. And keep doing what you do. You know, hire the people that you want to hire. Just don't make it expressly about the fact that they're in a protected class. Get the people you want to get. And it's actually funny because if you're in a business like that and your staff is majority minority, like let's say you have like 90% minorities that you hire, and you decide, well, you know, I'd like to have some more Caucasian folks on staff. Theoretically, if you tried to discuss how we can hire more white people, that would violate these diversity measures. So, you know, if you have a majority minority staff, you don't have an obligation to include people to create a balanced staff. Actually, this would discourage you from doing that. So it's a lot of nonsense, but what it really comes down to is appearance over substance. Don't appear as if you're trying to hire somebody because they're in a protected class. Do what you do. If you talk about somebody, talk about merit, talk about how they fit on merit, and you should be fine.
Yeah, thank you. You know, what I'm hearing when I hear you, Carrie, is don't talk about it, be about it, right? Just
There you go. There you
if
go.
you're going to do it, do it. You don't need to announce it. If you are about inclusion, your actions are going to speak to that, right?
There you
How
go.
you operate is going to speak to that. Todd, it looks like you itching to say something. So
Yeah, he
I'm,
is
I'm,
itching.
I want my sister Monique to chime in because I'm gonna sit over here and bite my tongue. I'm gonna keep doing what I'm doing.
So the only thing that I would add to what Attorney Davis had said is to just make sure that you, and like with any recruitment effort, you have to comply with federal non-discrimination laws. So if you remove those words, always remember to say that you are an equal opportunity employer that complies with federal non-discrimination laws, because you don't want to go the other way, right? And just exclude people because of their race, because of a fear of being attacked for supporting DEI. So that's the only thing that I thought was omitted from Attorney Davis'
Agreed.
thank
Good
you.
point.
So I wanted to add too that often, language has power, right? Words have power, and these folks are purposefully using things like unlawful DEI as if unlawful and DEI are together, right? We are now revealing that DEI is unlawful, right? And reiterating what Attorney Dixon said, which will probably be the closing words, right? That anti-discrimination, DEI, diversity, equity, inclusion, no matter which way the letters go, is not unlawful. It is not illegal. The law has not changed in that regard. And so this is really, in large part, not only about, impacting federal employees and subcontractors, but also having a chilling effect across the government and the country. Because just the question, right, and the comment that was raised around, should we change the word? Should I not hire so many Black people? Do I not work with Black subcontractors? Can I not support a African-American festival? Or do we not sponsor the MLK Day Parade anymore? All of these things come into play because the president says unlawful DEI is now, dead, right? And we're finding, we're searching websites and we're looking through job descriptions. And it is very important and impactful for individual federal employees and subcontractors. Very real for how they are going to have to now navigate their relationship with the federal government, right? So that is one piece of it that we're really leaning into today. But for other businesses as well, there is, and we talked about having a part 2, Sasha, even because of how they are now looking at private corporations, right, and private businesses, and how they can lean in. And remember, this isn't just, a couple of folks being like, we don't like DEI. This is the federal government that they are now leveraging, right? It is our tax dollars, and it is the vast resources that the federal government brings, right? And so this chilling effect is what I think other businesses, and whether it's primes and subcontractors and others, who are now beginning to question everything and how they then, what their own practices and procedures now look like. And to Monique's point, stay the course, because the law has not changed. You are still required to not discriminate in your hiring and in your firing and how you interview people. Those things are all the same, right? And so there is intentional chaos going on in this moment. And that's why having legal counsel is so important. And I will say also, if you're an individual or you're a business, you need to talk to more than one lawyer, because different lawyers have different legal strategies. And you've got to figure out what works best for you, what you're comfortable with, what you have confidence behind. Because some legal strategies are to play it safe. They are to say, hey, we don't want to litigate. So what is our strategy? We don't want to do X, Y, and Z. So what's our strategy? Some folks might say, hey, I'm Black and I'm proud, or I'm not afraid of what we're doing, because what we're doing is according to the letter of the law. It is our vision of our company or our nonprofit, and we intend to stay the course. And a lawyer can then help you formulate a legal strategy to let you know what your liabilities are, what your risks are. And that's the way legal counsel helps advise you to navigate through what is going on right now with our federal government.
And Keisha, I think you, I'm sorry, go ahead.
I wanted to jump in right
I
there.
think that would lead Todd in to just drawing them out. Go ahead.
You always baiting the hook. That's what you do. All right, so let's talk about it. If you're a contractor, meaning you are the one that holds the contract with the government, that's different than being an employee of a contractor. So it's important to know what the contract with the government actually says and what the terms are. And so when they start coming after contractors, the contract, just like they're sending out these templates, it becomes the binding agreement that sets the guardrails and the rules for what this engagement or this transaction might be. So I would say, first of all, know what's in your contract, including what are the provisions for modification or terminating the contract on certain expectations, right? So that's one. The other thing, though, is let's be real clear on, because all of this is the chaos that has come up since the Supreme Court came down with the ruling in UNC and Harvard. And that tucked away in a footnote, Justice Gorsuch kind of gave a nod and a wink to say, if you think this only applies to higher education, think again. That's the Yeary translation. That's kind of street lingo. But here's what the import of the ruling is. They say race cannot be a factor. It cannot change how you rank employees. It's like a weighting consideration. But then the Chief Justice said, well, but you can still tell your story, right? It can still, inclusion can still be a goal. It cannot translate into some distinct weighting of factors that leads to a violation of federal law around race. Now, if you're a federal contractor, or if you are connected to a program that relies on federal dollars, there is still, and we've got to spend some time, the lawyers have to spend some time wrestling with this, because I think Title VI is squarely a target that's next, because Title VI litigation, in terms of how public funds are used, actually permits disparate impact as a claim, when in many of the other modifications to the application of civil rights law, you have to prove intent. And so we've got to be really, really focused on what we do, how we do, and what the effects are going to be on the existing civil rights protections, because they actually have groups of folks sitting in rooms while we're on this podcast right now, talking about how they're going to come up with their own test cases to further dismantle the progress that has been made on inclusion, starting with race, but extending then to gender, to ableism, to veteran status, to a number of factors that have been part of the inclusion framework. What they've done is they've created this boogeyman that says every time you say DEI, it means that some unqualified Black person is going to take a position from some overqualified white person. And so we've got to be real clear on the framework so that we don't just push the panic button. We've got to be very, very careful and creative, and also recognize that we're going to have to take a lot of this to the courts ourselves. This is the test case framework in the 21st century that Constance Baker Motley, Thurgood Marshall, Charles Hamilton Houston used to advance civil rights in the 20th century. They've used it now to erode it. We've got to reinforce it. And we've got to make sure that, first of all, we know what the rules are. Read the words of your agreements, your contracts, your personal handbooks that say to you, these are your rights, because any labor and employment lawyer who's going to have a conversation with you is going to want to review that to understand what are the terms that, while they might not be binding, they certainly inform the decision-making about whatever your role might be.
Thank you. And I'm glad you brought up the case around affirmative action in higher education, because that is what's being used. Because it shifted in higher education, that now means everything, which is not the case, right? And that is specific to admission. That is very specific to admissions. So I think also it's this overreach, overstretch of what that case is and was. And as someone who spent 10 years in higher education, or a few years in higher education, it's something that it's very top of mind for me. And so it goes back to what Attorney Dixon said around continuing the course, but you have to do so with intention. If you know what you want your end results to be, that's what you need to focus on. What is your intention? So if that is recruiting at Jackson State, if that is recruiting at Spelman, if that is recruiting because those are the best candidates, and also knowing your customer base or your client base, right? You have to keep that in mind as well too. So none of this is illegal. And so I just want to make sure that we're clear there. I'm also checking the comments to make sure that we are touching any questions. Keisha, is there anything else?
Yeah, there were a couple of questions that we did touch on through the conversation. Specifically, there was one around, and I encourage folks to, when you see the contact information, to capture that, because the ability to talk to an attorney to really, like they said, your handbook, right? Whether it's your union handbook, whether it's your department handbook, whether it's your federal contract that you have, the devil is in the details. And oftentimes we're signing things and we don't know what's in them, right? And so when people let us go, we think they have the right. And quite frankly, we're shocked sometimes when we learn that they have the right, because we didn't know that that was actually in our own contract. So if you are a federal contractor in particular, and you are worried about sort of what comes next, because not even because you're on a DEI project, but because you are Black, because you are Latina, because you are a woman-owned business, because you are a veteran, right? And everything is being thrown into the DEI pile, I highly encourage you to speak to an attorney, right, at this juncture. And there was one question, Sasha, around a federal contractor who lost their contract, and she was supporting a contract that was DEI. And she's like, I'm looking for a job. My company has no positions, but I'm not a DEI person in the sense that that's the work I do. I'm just a federal contractor, right? Yeah. So Todd or Carrie, what would you say if somebody came into your door and they said, I'm a federal contractor. I lost my contract as a result of some of what's going on. At least that's what I was told, right? That this is tied to the DEI ban. What should I do? What's something that you would tell some of these folks coming in your door?
Well, I think the first thing to think about is, what your rights are as a contractual employee. So you'd want, if you have a specific contract that defines the term of your employment, if you have a union handbook, if you have something, an employee handbook, the first thing I'd advise somebody is, let's figure out what the terms are of your current employment with the contractor that just ended. So that we can determine, were there any violations with respect to that? But as an employee of a federal contractor, you're going to have the protections of a private sector employee, which are not much, but you do have anti-discrimination protections. You do have any contractual protections that you came in with. And so we'd have to start there.
That's great. No, I appreciate that. Todd, can you take it from the angle of, I'm a federal contractor, like I have the contract, and I've lost this contract. What should I do as a business owner, in business with the federal government with this contract that I've now lost?
Well, before I would start with answers, I would have a few questions. One, let me see the contract. Let me see the notice that was given to terminate the contract. Was the termination provision in keeping with the contract, or do we have what in classic contract terms we say is a breach? What are the recourse provisions in the contract? If there is some violation, you believe, of the terms of the contract, many times it will lay out what that path and coursework or process might be, rather. And then also what the time frames are to be able to address it. And so if there are concerns, I think what I would be looking for is to gather as much information about the particular facts of this contract relationship what the framework was or may still be. Are there lingering protections that even though the compensation may have ended, certain provisions may still be present and current? So each situation, as you mentioned earlier, Keisha, is different. And so I think before we jump to the answers, we've got to make sure we're asking the right questions so the answers are informed by the information and the data that we receive.
And just to jump in and supplement what Todd said, which is very, very important, very important. The contractor, if they feel like the contract itself is in jeopardy and they feel like the funding is going to be cut off, let's say they do a lot of DEI work, they're going to want the right exit point for that contract that's going to prevent them from doing uncompensated work. So if the funds are going to be frozen, you need assurances before you continue work so that you're not working for free. And I think that's an excellent time to get an attorney involved to figure out, what type of assurances are going to be needed in writing to make sure that the contractor can feel comfortable going forward. And if the insurances aren't there, how long should the contractor move forward before considering the contract terminated or suspended?
Thank you. Thank you both. So Keisha, I'm looking at our time, and so we probably need to wrap up. Todd, do you have any final thoughts, comments for everyone?
It's a chaotic time, which creates a heightened sense of anxiety because there's so much uncertainty. The certainty that you have are the rules that protect, particularly if you're in federal employment. If you understand what the status of your appointment is, if you're a political appointee, totally different than if you're a career or career conditional employee, and in terms of what your rights would be in the event that what we're hearing turns into what should really have been formalized as a reduction in force. But there's a process there. So this voluntary offer to get folks to take a resignation, and then they say, well, I'm not under duress, so you can't argue constructive discharge on the basis of some protected category. There's a reason why the language is what it is. And so while this podcast is not intended to be legal advice, right? We just talking about themes. I got to put that disclaimer out there because I don't want bar counsel in the several jurisdictions where I hold a state or a district license to come looking for me. But if we need to have a conversation specifically about your concerns, you're on the clock now. At this point, I'm not even sure. You may want to ask yourself the question, do I have enough time to make an informed decision about an agreement that would be binding on me with no recourse, because this process has not yet been challenged in terms of its legal efficacy in any federal court anywhere. I think those things are coming. They won't be resolved today. In the meantime, let's say you don't sign it. You still have the same protections that you had for your job before this letter went. Those have not been modified. And so you do not abandon them simply because the timing was not adequate for you to make an informed decision. So just rely on that. Know that if there's anything that any of us across the legal community who work in labor and employment law can do to try to help you, we want to be able to help you. But at this point, it's really up to you to make the best decision that you can based on your circumstances.
Thank you. Carrie.
Yeah, I think Todd summed that up excellently. The key with, advice, legal advice, is that a little can go a long way. A little can be very inexpensive. Getting somebody on the phone, having them review your documents, and getting an assessment about and a strategy about what should happen next can just pay phenomenal dividends in terms of your future and your future direction. And it can be done at a very inexpensive cost. And, it's one of those things that, a lot of minority folks don't realize is a tool that really should be in their toolbox. And so I would encourage people to always come back to that as a critical tool in navigating through, this society and navigating through their future.
Thank you. And Keisha, I will just kind of say thank you for, hosting this, because I think this is, again, one of many conversations that we will need to have as this continues to unfold. My advice, and again, I am not a lawyer, I don't play one on TV or anything like that, is to do your research on who you want to represent you, because there are some lawyers out here that are on the side of business and the side of the government and will give you advice based on that. And so I think it's important to find someone who has you in mind, right? That really wants to be on your side in this process, because you want to be able to do what is best for you. And so I will say that. I will leave it there. Thank you both for Carrie and Todd and Monique for being here. Keisha, thank you for the invitation. And I am just looking forward to part 2 and beyond. So thank you.
Yes, thank you. Thank you. I'm so excited because also there's been such a robust chat going on, right? So between our viewers on YouTube and LinkedIn and Facebook, we're seeing engagement from all different angles. And I hope this also reminds folks that you're not alone in sort of these questions that you're having, and that the legal community itself is furiously at work, really trying to really, in the totality of what we're facing, right, as it relates, you can see the conversation went to federal employees, the contractors, to the private sector, to all different angles, the education and so forth. And for the legal community, this is serious business, right? We are charged with serving the public and also vigorously advocating on behalf of our clients. And we take the analysis and the interpretation of the law very seriously, right? And being able to advise people on how they can navigate their own life circumstances. And this is a situation that we have not seen before in our generation. And so being able to know that there are legal resources, not for the nice to have, but we are in a state of must have. Right? You should not, and this is of course not legal advice, but you should not be signing documents, whether you are a contractor or employee, at this point, without having someone look at it. Because we are not dealing with the same level of integrity that we are used to be able to say, it's coming from the federal government. We're seeing things where they are turning it back 24 hours later because their own lawyers, let me tell you, are saying, oh, we've gone too far on this one. Right? And they know a lot of this is going to be challenged in court. And they also know that most of us don't have legal counsel on speed dial to help us navigate. But little do they know is that in community, leveraging social platforms, tapping into our churches, tapping into our networks and our civic organizations, and just our families and friends, we have the resources that we need. And so I implore folks not to just suffer in silence or in silos, but to tap into their resources, do their reading, and before you sign anything, right, really, truly, get somebody to tell you what's going on in that document. Because no lawyer is going to say, you must sign this or you should not sign that. They're going to tell you what the document what it says, right? And without the legalese, if you will, what you're exposed to, what you can't do, what you can do. And that's the information that you need to make the best decision for you and your family. And so I thank so many folks for tuning in. Continue to engage with us. Let both, Todd and Carrie and Sasha and myself know how we can be of continued service to you. Subscribe to Justice Connection. I'm always going to tell folks, I am honored to be able to connect with so many brilliant attorneys who are truly passionate about advocating and representing and protecting the community. So have a wonderful afternoon, and we'll see you next time. Let us know what you want to see next, and we'll see you next time. Thank you so much, Sasha Thompson, Todd Yeary, and Carrie Davidson.
Thank you.
Take care.
Take care.